to that?
No.
Okay. M, N, the fact that the defendant's been indicted by a grand jury is not evidence. I assume no objection to N.
Okay, I haven't yet, and no objection.
Okay. Instruction O is a concert of action instruction. Any objection to that?
No, Your Honor.
Okay. P is if anything is rejected by the court, you can't consider it. Any objection to that?
No objection.
All right, Q is a malice instruction, which also goes into heat of passion. Do you have any objection to that?
I don't have
Well,
it
if
in
you're
that
giving a
order,
heat of
Judge.
passion instruction, then wouldn't you be second-degree waterfall?
The next instruction after,
I'm just asking a
Oh.
question here.
I'm sorry, Your Honor.
Your instruction Q has the definition of malice and also heat of passion.
Yes.
So if we're giving a heat of passion definition, that's a second.
And again, Judge, depends upon whether or not the defendant testifies. There would be a replacement for malice that does not include heat of passion.
Is the defendant going to testify, Mr. Carroll?
yes,
Yeah, excuse me?
yes.
He is going to testify.
Okay, then presumably, depending upon what he says, this
Okay,
would
so
stand.
Q, so you don't have objection to Q then?
That's Q's malice?
Malice and heat of passion.
I believe that's a model, Judge.
Okay, that's fine, it is. Okay, Q. R, that's inferring from a deadly weapon. Any objection to that? Inferring malice from a deadly weapon? It's a model instruction as well.
No, Your Honor.
All right, R.
And that's
Instruction-
R?
That's R. Instruction S is that you've been instructed on more than one grade of homicide. Any objection to
Presuming
that?
there's a waterfall.
Right. Any objection to that? It just goes down the different,
Yeah, it was just a little out of order on this.
okay, that's fine.
I don't have an
All
objection
right,
to that.
S. Instruction T is just you may infer that every person intends the natural and probable consequences of his acts. Any objection to that?
Yeah, no.
All right, so those are the commonwealths that we have now. So what we're missing from the Commonwealth is the chargings for the aggravated murders, the 4 counts of aggravated murder, and the 1 of child abuse, correct?
Yes, ma'am.
Okay, so we're set on those, so I'll just put J and K to the side because it sounds like they're going to change anyway. Okay. Now let's just go through the rest of Mr. Carroll's just to see what we can add to that stack as of now. All right, I have instruction 2, the Commonwealth bears the burden of proving beyond reasonable doubt the identity of the defendant as the person who committed the crime. Any objection to that one?
No, ma'am.
All right, 2 will be given. You may consider the character of the defendant when proven by evidence, whether good or bad, along with the other circumstances. Any objection to that?
This was duplicative of our B, which I thought the court had included.
I have B, but B is Banfield does not have to testify, which might be taken off, but might be taken out if he does testify. But instruction 4 is different. Did you have any objection to instruction 4?
I'm sorry, Judge, I thought we were on instruction 3.
That was withdrawn.
Okay, got it. Instruction 4, no objection.
Okay. Instruction 5, the fact that he's indicted by grand jury. Did we already have that one?
Yes.
Okay. So you withdraw 5, Mr. Carroll, since we already have that one. Let me make sure we have it. That was instruction N of the Commonwealth, so I can withdraw 5, is that correct?
Yes, Your Honor.
It's okay. Again, 6, rejection of the court, that was Commonwealth's. Do you have it there? Commonwealth's instruction P, as in Paul. So you withdraw 6?
May not
It's the same
consider-
as their P.
Okay. Yeah, I do,
Okay.
Judge.
Instruction 7, I mean, I can get, I mean, it says upon requesting any exhibits introduced in evidence, I send them automatically to the jury, so I don't think we need that. If you want to withdraw 7?
Withdraw.
Okay. Then we skip to 10, all right, because he's already withdrawn the others. Instruction 10, the statements presented to you being made by the defendant is submitted for your consideration along with other evidence, assuming he testifies. Any objection to 10?
No.
Okay. 10 will be given. 12, if you believe from the evidence the defendant previously made a statement inconsistent with his testimony at this trial, do you have any objection to that if he testifies?
No, ma'am.
All right, 12. 13, any person sentenced to a term of incarceration for felony offense shall not be eligible for parole upon that sentence. That's a sentencing instruction, Mr. Carroll? I mean, if it's my understanding, the jury's not sentencing, correct?
Yes, Judge, and I just put them all together.
So we can
yes.
withdraw that?
We can withdraw that.
Okay. And I think 18 is to say, under the charge against the defendant, you may return one of the following verdicts. Well, I guess, would that be the verdict form? Or
That's the verdict form, and Judge.
Yeah.
Can we
would-
withdraw that then?
We can withdraw that.
As a jury instruction. I think instruction, I don't know how you have these numbered now. 13, oh, that was instruction 14, I'm sorry. And this is 15, is a verdict form, so I can withdraw that?
Yes.
Okay. Instruction 16 is the co-defendant has testified she was an accomplice in the commission of the crime. When you find your verdict upon her uncorroborated testimony, you should consider such testimony with great care. The defendant may be convicted upon the uncorroborated evidence of accomplice. Any objection to 16?
No, ma'am.
16 will be given. And this is 17 is a sentencing instruction, so again, you want to withdraw that? Okay.
Yes. Withdraw.
Then your aggravated murder waterfall charge, I'm just going to put those to the side, 18 and 19. Okay, we'll get back to those. Okay. 20 is a self-defense instruction. Again, if he takes the stand, any objection to
No, ma'am.
20? Okay, good. Instruction 21 is also another self-instruction, a self-defense instruction, reasonable belief of imminent danger. Any objection to that if he takes the stand?
Hold on just a second, Judge, because I
Sure.
had difference between murder and manslaughter is malice.
Okay.
Are we looking at,
I'm looking at 21. He had a 21, which just talks about the burden of proof for self-defense. And then, which you didn't have an objection to, then 21, this defense is governed by the same principles but applied to self-defense. Defense of another person versus self-defense.
okay, I know where those are. Hold on just a second.
Okay, sure.
Okay, so there at the bottom. Is this if you believe the defendant was without fault in provoking or bringing on the killing?
No. it's-
One more down from that?
Yeah,
Perhaps?
this is, yeah, his in 21 is the defendant contends that he acted in
Act in self-defense of another person under Virginia law is, okay.
Yes. Any
Got it.
objection to that one?
Judge, I'm unclear. This is, his site is the annotated jury instructions defense of another. I don't think that this is the form that instruction is.
I can put it to the side if you want to take a look at it. and
Yes,
make sure.
please.
Okay, so 21 we'll just put to the side for now, Mr. Carroll, okay?
Yes.
All right. 22, again, that's first degree, that's the waterfall for first degree, so I'm going to just put to the side since we're going to go back to those charging instructions. Same with 23. 24 is the same definition of malice and heat of passion that we already have. I just, let's see if I can find which number it was, or letter. All right, that's Q. Instruction Q is the same as your 24. Do you want to withdraw?
24 withdrawn.
Okay. 25, the difference between murder and manslaughter is malice. I'll just put that to the side till we get our waterfall instructions, okay? 26 is you may infer malice from the use of a deadly weapon, which I think.
We already have that in.
Yes. What number is that? Do you have it just
That
for the
was-
record?
Thing.
Or letter?
I'm pulling it up, Judge. Willful deliberate.
Deadly weapon.
Deadly. R.
R. Okay, so R is the same as your 26. Do you withdraw 26?
Yes, Your Honor, we'll
Okay,
withdraw
withdraw
26.
26. Then we're skipping 27's already been withdrawn, so we get 28. Once the Commonwealth has proved there was an lawful killing, then you may, but are not required to infer that there was malice and that the act was murder in the second degree, unless you want to just put this to the side for the
Yes, please.
charging instructions. Okay, we'll put that to the side, Mr. Carroll. And then we have 29. Again, that seems to be the verdict form, so or actually, that's another charging instruction for second degree. Okay, so we'll put that to the side. All right, instruction 30, that's a penalty instruction, so I assume you withdraw that.
Withdraw.
Okay, 30 is withdrawn. And then you have an instruction for felony homicide. I'll put that to the side with our charging instructions for aggravated murder. Instruction 32, to be in the commission of aggravated murder requires the killing result from an act that was an integral part of an aggravated murder, an act in direct furtherance of an aggravated murder, and an act necessitated by the aggravated murder. Any objection to?
Judge, we already put that in without the word aggravated. The model does not use the word aggravated, it just uses.
Okay,
murder.
which number is
I'm
yours?
looking. To prove the charge of murder, Commonwealth does not prove motive. That's the one we're on, Judge, right? That's our M.
It's your N?
M as in Mary.
Him. All right, do you have any objection to withdrawing yours with instruction M, or would you rather have yours on instruction 32?
I'll withdraw mine.
You withdraw yours? Okay.
Yes.
Instruction 33, to prove the charge of aggravated murder, the Commonwealth does not have to prove motive for the killing, the presence or absent motive. We already have that as Commonwealth's.
Oh, no, sorry, Judge. Motive is M. Which one? I thought that's what we were on.
No.
What did he
were.
just withdraw?
Oh, yeah, motive is 33. The one he had before that, 32, is to be in the commission of aggravated murder requires that the killing result from an act that was an integral part of the aggravated murder, an act in direct furtherance of the aggravated murder.
And Judge, we don't believe that one is appropriate because we are not proceeding under the aggravated murder in the commission of robbery, rape, et cetera, the enumerated other felonies, so I don't think that one's appropriate.
So that would, they're only under subsection 7 or 8, which doesn't,
Right.
so did you
So I'll withdraw that.
withdraw that? Okay. And then 33 is the same as
33
instruction
is
M. So will you withdraw 33, then it's the same
Yes.
as instruction M? Okay. Then you have instruction 34, which again is the guilt phase, so I'll assume you're withdrawing 34 and 35?
Yes, ma'am.
Okay, we're getting there. And then instruction 36 is another self-defense instruction. If you believe that the defendant was without fault in provoking or bringing on the killing of Joseph Ryan, and if you further believe the defendant reasonably feared under the circumstances that appeared to him, then he or others were in danger of being killed, or that he or others were in danger of great bodily harm, then the killings will be in self-defense. Any objection to that 36?
And that's the one that cites 33-800 as the
Yes.
model? That's fine.
Okay, so we'll have 36. All right, so those are all the agreed upon ones that we have for now. Obviously, I'll take the one out. If he does testify, I'll take the Commonwealth's one out that talks about that he doesn't have to testify. All right, but for right now, for Melissa and for everybody else, let me just read the jury instructions we have as of now. Instruction A, instruction B, instruction C, instruction D, instruction E, instruction F, instruction G, instruction H, instruction I, instruction L, instruction M, instruction N, instruction O, instruction P, instruction Q, instruction R, instruction S, as in Sam, instruction T, instruction 2, instruction 4, instruction 10, instruction 12, instruction 16, instruction 20, and instruction 36. Okay, so that's what I have so far. We will discuss at a later time the child abuse charging instruction and then the aggravated murder instructions with waterfalls after we have more evidence.
Yes, ma'am.
Okay, does that sound about right?
Yes.
Okay. All right, so these are all the ones that are withdrawn. Hold on to those. Let me make a couple stacks here. Anything else at this time?
As to the jury instructions or as to anything
But
else?
as to anything at this point, I think that we've gone as far as we can with jury instructions at this
Yes.
point.
So, Judge, I do have,
Just get a little closer to the microphone for me.
and I'm more than willing to approach if
That's okay, you can do it from there, that's
Okay.
fine.
Your Honor, I have an expert witness who I've noticed and I've been trying to move around.
Okay.
It's the person that, before we added this extra day, I had planned for Monday. He made arrangements for Monday. I tried to get him when we confirmed yesterday to try to get here today, and he's unable to do it because he's flying in from Nashville. Now, that's much like all the other things, that's an issue relating to the weather. And so he's an expert that we need just based on what's been
Right.
said.
Can you do remote?
I don't know. I didn't think of that as a possibility, but I can. This is my situation, is every time I'm trying to get in touch with him is usually after we've been here all day.
Right.
And then, so I haven't had the ability to do anything other than back and forth on email. So I haven't checked with him whether he can do remote. And I can't rest my case until obviously I get my
Right.
expert in. So I can call him right now and see if I can catch
See,
him.
if you can do remote, we can definitely set him up, and it comes up, and it's very clear and everything.
Okay.
I assume there's no objection to him being remote.
This is the audio expert?
Yes.
Yeah.
Yeah, and I mean, it might be easier anyway, because he might not be able to get a plane flight
Well,
next week at
that
all.
was my worry, is we're all
Yeah.
going to be,
Right, so-
and I'll tell you, Judge, at the beginning of the week, it didn't look like it's going to be what it is looking
Right.
like now. And
Well, that's
so-
what, yeah, well, why don't you call him now, and if he can just set up remote, we can definitely get it done this afternoon at some point.
Okay, let me see.
Okay, whatever's good for his schedule, we can even break in between witnesses and just get him on his schedule, whatever's available for him.
Okay.
Okay.
When Your Honor adjourns, I'll go out and hallway her.
Okay, perfect, I can take a break right now, right? Okay.
Okay,
All right.
thank you.
All right.